State of Florida versus Sarah Boone. Look, the thing that blew me away about this trial was one, how nonchalant the DAs seemed throughout the entire trial. And then we got to rebuttal and I was like, oh, which is why I always say, I never know what they may have. We don't know all the evidence till it comes out. So you never know what they're relying on. This case, particularly so. The state was particularly chill. And then they got to their rebuttal case and just pushed play. And we were like, oh shit. Well, that's why you were so chill about everything. And the state was just like, we're just ready to go to trial. The Sarah Boone trial lasted about 6 days. She was convicted of the second-degree murder of her boyfriend, George Torres, for zipping him into a suitcase and leaving him there. He told her that he could not breathe. He told her to let him out. He tried to get out, and she prevented him from doing that, and then went upstairs and went to sleep, and the next day was like, oh. So she was convicted of second-degree murder. The jury was out like an hour and a half. I think they spent an hour eating dinner. This, again, do I speculate often? No, but when I do it all in one episode. Do I think the jury generally knew early on in their deliberations what they were going to do? Yes. Did the jury have dinner in the back? Yes. Did the jury probably want to talk about the case a little? Yes. Have I also seen juries that have said, well, we had a verdict, but it felt like it was too fast to come back, so we just chatted for an hour because it felt like maybe it seemed like we should give it a little bit more time? Yes. Jurors are like, does it look bad if we're just like, we're done? After 6 days of trial, does it look bad if we take 3 minutes to do this? Maybe. So sometimes you have jurors that want to chat with each other. Throughout the entire case, they can't chat about the case. So it's not unusual that the jurors might be like, hey, we can talk. So I think they probably ate dinner, chatted, had a verdict, continued to chat until they were done, and then came back with a verdict. They're like, all right, hour and a half seems good enough. Let's go. Send it. It's 8:00. So yeah, I think they could have probably come back faster on that, but I also think they maybe wanted to have a moment, because imagine not being able to talk about all those videos. You got to wait till the end of 6 days to talk about it. So defense attorney Owens for Sarah Boone has filed a motion for new trial on essentially the same grounds that we saw throughout the trial, saying that the court erred in ruling that the defendant was not entitled to court-appointed counsel when more than 7 court-appointed counsels got yeeted off of the case by their own motion. They were like, please let me out. And Sarah Boone was forced to represent herself before James Owens parachuted into this case by choice. They say that the court erred in denying counsel's multiple motions for continuance. I think the court was pretty clear on that when we were watching the pretrial motions, saying if you come into this case, you are accepting the trial date as is. You knew when you chose the case. And then when Owens was complaining about not getting a continuance, he also complained that he doesn't live in Orlando. It's not like that's new information to you, sir. Then they're saying the court erred in failing to grant a new trial when one of the individuals in the audience had an emotional outburst in open court. Notice in this motion, he never talks about what that quote unquote outburst was. It was not something that was so great we heard it on the live feed from court. It's not something that seemed to cause a tremendous disruption. Someone seemed to have an emotional response to a video and then left the courtroom. But he asked for a mistrial. The court did not grant it. The court called it a minor disruption. And he did not ask that the jury be inquired as to whether or not that impacted them. He didn't ask for that to my memory. And he didn't ask that there be a special jury instruction that they're to disregard that, though I think the jury instructions very well cover, and the jury instructions in Florida I found more clear than those in Massachusetts. The jury instructions well covered. You're not to base your verdict on sympathy for any one side, on empathy for any one side. It's to be based on whether this law meets what happened here. I thought those instructions were quite clear. He also said that the court failed to disallow the opinion testimony of the state's rebuttal expert. We heard lots of this argument that day in record. That testimony was probably 4 minutes of testimony and 4 hours of sidebars. That's minimal hyperbole because I don't even remember what actually was testified to, because every other sentence there was a sidebar. And then he said that the state committed prosecutorial misconduct by making a second closing argument instead of a rebuttal. So the defense is also salty that the state's rebuttal argument slapped. That was a proper rebuttal. The rebuttal argument is to rebut what the defense said. And I think that in the rebuttal, the state did that. But a rebuttal doesn't have to be boring. It doesn't have to be an attorney with a notepad. In fact, I hate watching these rebuttals where it's like the defense said this and then this, the defense said this and then this. The rebuttal was fluid. The rebuttal talked about the suitcase, talked about how Sarah Boone may or may not have hit him in the suitcase, talked about the emotional aspects of the case, and then said, I'm not going to belabor it. Your dinner's waiting in the back. I thought the rebuttal was impactful. I thought it was concise. And the defense's closing was wandering and hard to follow. And numerous times during Owens' closing, he kind of gave the, you guys, I'm trying my best. So help me out here. And that's what this motion feels like to the court. I'm doing my best here, Your Honor. So help me out. He does say that he was not as prepared as he would like to be in this complex trial. But again, that was Owens' choice. So Sarah Boone's currently set to be sentenced December 2nd, 2024. We will see if this comes to hearing before that. If it does, I'll be streaming it because you want to watch it. I want to watch it. I want to see Judge K say no again because he said no on all of these. And this is coming before Judge K, this motion for new trial, which is typical after a conviction. Judge K is going to deny it. Then an attorney might choose to appeal it. But at the end of trial, we saw Owens say he was not going to be appellate counsel. So once this is denied and Sarah Boone sentenced, Owens will be off the case, and then appellate counsel will be appointed from whatever branch of the public defender's office locally handles the appeals, and Sarah Boone will have an appellate attorney. The real question here is, does Sarah Boone also write a letter to the court about this motion for new trial? That's really what I want to see, because this motion is going to get denied. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.